ladies, you can't start a fight hitting on somebody. Should a guy hit a lady back? Absolutely not. But you can't fight a guy and then say, oh, don't hit me, I'm a lady. You can't steal from JCPenney at North Star and then say, oh, don't chase me. Don't grab me and bring me back to the store because I'm a lady. You've gone from committing a robbery that you went to prison for to now it's aggravated robbery. And I don't know why people who are in the wrong feel the need to pull weapons. I mean, both you, from what I read in the stipulations, both you and the person, your ex that you were with, you all were stealing from JCPenney at North Star. And this person is just trying to do their job. It's already passed.
May 25th?
Yeah.
But, oh, he filed it last night. It may not even be the file yet.
Oh, okay.
Yeah, it's all right.
All right. So you're in jury trial?
Yes, ma'am.
All right. So everyone, please whisper. When do you think the trial will conclude?
Thursday afternoon.
All right. So when do you want this called back? Because I know sometimes you have to have some downtime from a trial.
Well, I'll say this. I'm out of town the first 2 weeks of July. Going to Canada, right? So sometime either between then or after that, if that makes sense.
All right. So you want July 15th?
We get back on the 16th. I would say the 17th or later would be ideal.
All right. You want to do it the 18th?
That works.
All right.
Just set date, and I'm gonna see if we can get the bond thing modified. What? Yeah. Same time. We'll just screw it. Wait, actually, when I signed this, all the coordinator, so we got the crazy week. Yes. Just right. You're good. I promise. Are
you ready or not?
Not yet. I'll just drop it today. And just put much stuff in.
All right. And so when you come back on the 18th, we're going to give you your jury trial date for this.
Sounds good, Judge.
All right. Once you sign the reset form, you're excused.
Thank you, Your Honor.
All right. And I talked to you about being late last time and you're on time.
Early.
Yeah, you early. And thanks for, thank you.
They preserved it. So that's what we're asking for continuance based on.
And state, how long will it take you all to see if there's dash cam?
2-3 weeks, rather than max.
All right. So is July 15th enough time?
That should be sufficient.
All right, we're coming back on July 15th for the dash cam.
Thank you.
You're welcome.
Okay, thank you.
He needs a reset form.
Okay, I'm not letting him go, Your Honor.
Okay.
I'm just having him have a seat.
All right, litigation information to the
Yes,
state.
I emailed to Escobar.
Okay. And what are you trying?
What's up?
What are you trying?
It's a harassment of public servant in 144.
All right, when do you expect your trial to be completed?
Tomorrow.
All right, so I'm gonna recall this for the plea deadline date to June 17th.
Okay.
Once I give you the reset form, you're excused.
Okay, thank you.
I really didn't like
Manuel Cortez.
Judge, that's my client.
I just have a quick question for the court. I talked with Mr. Garahan. I thought we had a plea worked out, everything. Then I just found out my client is a resident. He's not a citizen. So he hasn't talked to an immigration court attorney. I would have advised him to do that before. I mean, I've explained to him what the consequences are, but Mr. Garahan explains that the court feels more comfortable if he has, talks to an immigration attorney.
All right, Manuel Cortez.
He's in the hallway, Judge. Let me go.
Oh, tell him to come in. Hello. Hey. All right, thank you. I'll call you next. And you're on this side. All right, your client's in the center.
Oh.
Your client's in the middle. You're on this side for
Okay.
security
Sorry,
purposes.
Judge.
All right. So are you appointed on this case?
I'm retained, Judge.
All right, so are you going to get an immigration attorney?
Can you give me immigration?
Yeah. All right. All right, so I'm recalling this for July 8th.
Thank you so much.
All right, I'm going to give you a reset form. Once your client signs the form, you're excused.
David, we could, that judge has said, oh,
That's a Monday.
would it be possible? I think we're coming back from vacation on that night, on that day. Can I do it the next day? For the
Yes.
meeting to the court?
All right, it'll be July 9th.
Okay, thank you so much, Judge.
You're welcome.
Someone's wanting to
Okay, awesome. Well, is there anything you need from the court?
Can I tell him to something to my attorney?
Sure.
En el futuro. Yeah, yes. He's wondering if it's possible that he could get permission from the court to go to Mexico at one point or another in the future.
Oh, to go where?
Mexico to visit family and stuff.
Oh, I'm sure that'll be fine if everything is working well with him. I don't think probation or the state will have any objections to that. So just let the court know.
Yes, ma'am.
All right. So probation, how's everything going?
Judge, based on the report that was received from him, his CSO, he's been doing very, very well. They've not had any concerns. Nothing is going on. I mean, he reports on time, he's doing his drug tests on time, the field visits are going good. Like, they don't have any concerns at this point.
Yay.
He's listening to his lawyer
Okay, that is so awesome.
and to the court,
Yeah.
especially to the court.
So when does he think he wants to go to Mexico?
Your Honor, I think by the end of this year or January on the next year.
Okay. All right. If something changes, just let the court know and we can come in. All right. So when do you, yes.
Judge, I do believe Mr. Ross Evans is currently on field visits once a month.
Mhm.
I would ask at this point, we can see about dwindling those field visits once every 60 days or 90 days.
Okay. So we'll start with field visits once every 60 days. And then what I'll do is I'll bring us back here to see how you're doing. And then if he's still doing well, we can put it at 90 days. Then we'll bring it back and then it'll be at probation's discretion.
Yes, Judge.
So we're just doing things step by step so people don't get overwhelmed, okay?
Yes, Your Honor.
All right, so do you all want to come back at the end of August?
Yes, ma'am, that would be good.
All right, so we can do August 26th.
That would be fine. Your Honor.
Okay. All right, so we'll be back on August 26th. Do you need a reset form?
I believe so, just because
Okay.
it's in August, please.
Okay.
I'm very proud of him, Your Honor. He's doing
Yes,
everything
I am
right.
too. He's doing excellent. I always get giddy when people are doing well because I want everyone to succeed.
I believed in him from day one.
I know you did.
Something about him that after many years of working in this business, you can tell who's good.
Yes. All right.
Thank you, Your Honor. Thank you so much.
Thank you. Thank you so much. Yeah.
May he be excused.
Oh, once he signs the reset form,
Yes.
then we are excused. Have a great rest of your day.
Thank you, you too, Your Honor.
Just one second. Let me, oh, yes, I do. Do you need it? Okay, sure. Oh, and I need to write something down. Oh, no, you know what? I'm done with that. All right, Martin Torres.
He is the individual who was being tested for COVID.
All right, and so do you have the results?
I don't have the results yet.
All right, so we'll,
What I want to explain to you, we were here for discovery issues.
Mhm.
And the state said there are no changes in the discovery at this point. Since I don't have the results yet, I want permission to go to other courts and then come back and see if I get results.
sure. All right, thank you.
Thank you.
Julexis Brown. Thank you so much for dressing appropriately for court. Okay, so where did you get your name, Julexis?
My mom made it between a car and a diamond. Back then, her favorite car was a Lexus.
Okay,
Yeah.
okay, that's a nice story. Jewel and Lexus, okay. All right, so we're supposed to be here. They're supposed to have CPS records today.
We got CPS records yesterday.
Okay.
And we have an agreed PO, Your Honor, that's ready for your signature, and then
Okay,
we'll have the staff dupe the disc, and then Val and I are gonna coordinate for getting that disc.
okay.
Thank you, Joe.
You're welcome. All right, and state, were you able to tender an offer?
Not this time, I haven't seen them, they only came in yesterday,
Okay,
so. Not yet.
all right. I am going to recall this.
Yeah.
We're gonna come back on July 9th.
Thank you, Judge.
Thank you, Judge.
All right, once you sign the reset form, you'll be excused.
Thank you.
And state at that time, you need to be prepared to tender an offer.
Again,
Hi. All right, you all are scheduled for jury trial today.
I filed a motion for continuance yesterday. I came in last week and talked to the state. I talked with Daniel Escobar. They're not opposed to the continuance. We requested medical records from the primary care provider of the deceased complaining witness. It was over 1,500 pages. Was in back-to-back jury trials. I've been through most of it, but at this point, what's telling is that particular complaining witness went to his primary care provider the day before and verified that he was taking 20 different medications.
All right, so let me stop you. One, I don't have a copy for the motion for continuance, so
Sorry.
here's my question. I don't know anything about your case. This manslaughter case, is it involving a vehicle?
It is.
Okay,
Both parties were in a vehicle.
all right. So this is, I guess, alleged to, well, the state is alleging it's manslaughter. I'm assuming there's
We,
accident or
it
something.
is, and the
Okay.
point of contention is going to be causation. So that's going to be a heavily litigated issue.
All right, we're going to go on the record. Court is calling 2023 CR 8868, State of Texas versus Samuel Brock. Could I have parties announced for the record for the state?
Andrew Harrison.
Defense,
Jody Sawyers.
and are you Mr. Bach?
ma'am.
All right, defense has filed a motion for continuance. State, do you have any objections? All right, so this case has been going on in this court since January 2024. and I'm just receiving information that there may be medical records for the complainant. Why am I just now receiving this?
That's a great question. The state asked for 3 continuances while they said they were talking to the complaining witness, and we thought we were going to work this case out. And when they talked to the complaining witness, they still had to talk to their superiors. So the state got 3
Right,
continuances.
complaining witnesses, it's a manslaughter that they,
Their family, his family.
the family,
I
okay.
apologize. To be clear, his family. So, I mean, we thought we were going to resolve this case. And that's what we were led to believe at the last setting that we had. We were not able to resolve it. And that is what shifted gears. So we are not, I mean, we have the records, but we don't have the records that are behind the autopsy report that we now need, because as I put in there, the drug screen initially says no drugs detected, but now I need the underlying data because I have something that actually contradicts the fact that this particular complaining witness would have and should have had stuff in his system.
so you're assuming that because he was prescribed these medications, he was taking these medications?
Well, he said the day before to his doctor, he was taking them. So that, and coupled with the fact that I need to see what they screened for, it's possible that they didn't test, that these wouldn't have triggered, and I need to know that. So that's where we're looking for that data as well from the state, as well as we need time to get experts, which we believe it will take us approximately 30 to 60 days. I'm asking for a reset toward the end of August.
Okay, I can tell you right now, we're not doing 30 to 60 days for a jury trial. You all are coming back because this is an old case. We've been dealing with discovery since January, and I know people don't think that's old, but in this court, that's old. So this is what's going to end up happening. We're coming back, and we're coming back on July 15th. On July 15th, state whatever records you have from the autopsy report, whatever medical data as it relates to drug testing needs to be turned over at that time or before that time to the defense. And defense, you need to specifically address with the state what you're looking for with regards to those records. And then you all need to be off record and talk to the inmate and see where the toxicology report is. Does everyone understand?
Yes.
The records that you've received, they're going to have been reviewed by the 15th. Okay?
Now, Your Honor, just to let the court know, I have had a vacation letter on file for the 15th through the 22nd for months now. It's my 50th birthday.
Oh, no, you got to celebrate your birthday. So we're going to come back on July 10th.
Yes, thank you, Your Honor.
All right. Oh, and happy 50th.
Thank you.
They say that's the best one.
I keep saying it only comes around once, and I was like, so did my 49. I don't understand why we're.
And you know, when you tell people you're 29, that's the one that they don't believe. Because when I was 29, they're like, you're not 29. Either, you know, nobody is ever 29. They act as though that age does not exist. But oh, when I was 50, those were the days. Someone for the state, it's Criminal Trial Division. Court is calling 2024 CR 4983, State of Texas versus Jessica Marie Bonner. Can I have parties announced for the record for the state? Defense?
Sean Sheffield.
Are you Miss Bonner?
Yes, ma'am.
Counsel, have you received all of the discovery? Did you review it with your client?
I did hear.
Miss Bonner, did you sign the document entitled Application for Deferred Adjudication or Community Supervision did you sign that?
Yes.
And did you review it with your client? Did you review the document entitled True Bill of Indictment with your attorney?
Yes.
Did you understand it?
Yes.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
All right. Did you review the document entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions with your attorney? Did you understand it?
Yes.
Did you sign it in all the appropriate places?
Yes.
Did you understand you're charged with the offense of fraudulent use of possession of identifying information, less than 5 items, elderly person? That's a 3rd-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, court does not have to follow your agreement. If for any reason the court does not follow your agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand? Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand by entering this plea, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine? Counsel, has your client been able to provide you with any defenses?
She has.
Do you believe she has a rational as well as a factual understanding of the charges against her?
I do.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, sir.
Ms. Bonner, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea? Anyone promised you anything other than the plea? Satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, there's a $2,500 fine. State is recommending deferred adjudication. There's to be restitution to Caroline Caldwell. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes, sir.
State?
Yes, Your Honor.
Did you agree? All right, so everyone, we're on the record. No talking behind the court reporter. If you need your person moved to the other end, they can be moved to the other end. Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
Yes.
Outside the agreement, state is requesting that your deferred adjudication be for a term of 8 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Caroline Mullins Caldwell. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contact.
State any evidence.
Contained in exhibit 1 and attachments. Your Honor.
No objection.
All right, you may be excused.
Thank you, Your Honor.
Did you review the document entitled Waiver and Consent to Stipulation of Testimony and Stipulations with your attorney?
Yes.
Did you understand it? Did you sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sir.
Anything you wish to say on behalf of your client?
Your Honor, we just asked court to follow these recommendations.
All right, what's the name of the complainant's son who allowed you in the home?
It's David Caldwell.
What's your relationship to him?
He was a friend.
All right, do you have any children?
Yes, I do.
What are their ages?
18 years old, 17 years old, 16 and 15-year-old.
And who are they with?
They're with their dad right now.
What's your drug of choice?
I was on meth, but I've been clean.
All right, were you clean when you committed this offense?
No, ma'am.
All right, so why are you taking things that don't belong to you?
I was in the wrong place. I needed money at the time with my kids and it was just opportunity and it was wrong for me to do it.
Who is Melissa Campos?
That I have no idea.
And is Child Protective Services involved in your case?
I don't think so. I'm not sure.
When's the last time you had employment?
Well, I was working as a cleaning houses and then I lost that.
Mm-hmm. All right. Anything else?
No.
This is what the court is going to do. Court is going to sentence you to a $2,500 fine. That will be probated.
Thank you.
8 years deferred adjudication. There's to be no contact with the following persons: Caroline Caldwell, David Caldwell, Melissa Campos. There's to be no unsupervised contact with minors. There's to be a referral to felony drug court. That'll be first. A TAP evaluation in custody. And then last, if none of those places accept her, then we can do a referral to Esperanza Court. And follow TAP recommendations if she's not accepted in one of those treatment programs. There's to be the UA hotline. Regular reporting by Zoom or in person. Field visits 1 time per month for 4 months. Then at probation's discretion. Proof of employment within 30 days of release. There should be no employment as a home health care provider or with minors or in housing. You can't be cleaning houses or any place where you're around money or checks. You understand?
Yes, ma'am.
200 hours of community service restitution. I'm going to order parenting classes. Once you complete parenting classes, the community service hours will be deemed satisfied, and there's to be restitution, if any, to Caroline Caldwell. Probation, is there anything else she needs? Is there anything else you need from the court to be successful? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel as your probation officer is not addressing that, you can come to court. We're here, but not on weekends or holidays. If you feel like you're going to use, pick up the phone, call your probation officer. And again, if they can't get you any help, come back to court. So I've read what's been given to the court. I've read the violation report. I've read the affidavit of non-prosecution. So here's the thing. I'm going to want the complainant in here. So y'all have the complainant in here. And based upon what's on in the affidavit of non-prosecution, she's going to need an attorney. I personally have never seen where you had a complainant who says something didn't happen on the family violence side. I've never had or seen the state bring criminal charges. However, she is subject potentially to criminal charges if a false police report were filed. So we're going to reset this. And it's going to be reset soon because I'm assuming that she's cooperative with defense counsel, hence the affidavit of non-prosecution. So we're going to recall this and the court will hear it and she'll need to be here, and we'll make sure that if she can't afford an attorney will be appointed to represent her. All right. So we're going to come back on June 24th for the court to hear this violation.
And just so I guess the state will be responsible for bringing the witness if they're trying to pursue the violation report in the case.
We will not be bringing her in. I mean, I wouldn't want to subject anyone to criminal prosecution.
No, that's why she's going to have an attorney appointed to her. And if nobody's going to bring her in, I'm assuming that she's the person who has this assault second against him or assault family case. Is she the complainant in that case?
For the, yes, the same person for the violation report, yes.
All right. So I'm assuming at some point the state is going to have to bring her in. Otherwise, there's not going to be a case maybe. So I'm going to schedule this for June 24th. And I will tell you, this is one of those cases where the rules of evidence apply. So this affidavit of non-prosecution, the rules of evidence apply. So somebody should probably have the complainant here. An attorney can be appointed to represent her if she decides that she wants to say that this didn't happen. So we're going to come back on June 24th. And I will give you a reset form. You're going to be found guilty and you'll be placed on probation, or I can sentence you to 3. Which do you prefer?
Probation.
All right. So this is what the court is going to do. The court will find you guilty. Court is going to sentence you to 6 years in the prison, suspended. Any suggestions on how long he should be on probation, state? All right, defense.
Request for you.
All right. Let me think about that and I'll come back.
Yes, sir.
So there's going to be regular reporting and you're going to have to report in person because the nature of your prior charge, I don't think they'll allow you to report by Zoom. Probation, if y'all allow him to report by Zoom, that's fine. But if not, you know, you don't have to. There's to be proof of employment. When's the last time you had employment?
November 2023.
All right, so there's going to be proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's going to be random regular UAs. Field visits. Somebody has children up here?
That sounds in the hallway, Judge.
And see, that's a young baby. And this courthouse is so germy. People just don't realize, and children don't even have their immune system built up yet. So it's going to be field visits 1 time per month for 6 months. And then at probation's discretion. 120 sober meetings and 120 days. And we're going to do supportive outpatient treatment. And the state is taking in consideration NITMAG numbers 759930. And the court is going to place you on probation for 5 years. If you complete everything successfully, then he can always come back to the court and ask to be terminated early.
Thank you, Your
Honor. Probation, is there anything else he needs? Is there anything else you need from the court to be successful?
No, I just want to thank the court for allowing me to stand on my foundation and go back and do what I need to do for me and my family.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
And you understand that based upon the nature of your order of the charge, you still have to make sure you stay in contact with them as well.
Yes, ma'am.
All right, we can go off the record. In this court, to be successful, communication with probation is key. Do you understand?
Yes, ma'am.
If there's an issue and you need help with something, ask probation. If you feel as though they're not addressing it, you can always come back to court. We're here every day except weekends. All right, good luck to you.
Thank you very much.
All right, you're welcome. Yes.
Your Honor, does he need a thumbprint on?
Oh, they'll take care of it. The deputies will. Thank you. All right, so who was talking to inmate?
She's already outside, Judge.
All right, thank you.
Yeah, excuse you.
Yes,
Thank
thank you. All right, who is here on Rick Contreras?
I am, Your Honor.
Yes.
Judge, Mr. Contreras came to court in the 170 this morning.
Mhm.
So he is obviously not here because he is down in 1.5. But I was disappointed on the felonies 3 weeks ago. There's evidence I need to review, there's videos, all kinds of stuff I need to review, the contacts of witnesses. So if possible, if we could just reset this matter.
Okay, so where's Mr. Contreras?
He's in custody.
Okay, have they brought him out?
No, he's in 1.5. He was on the 175th docket.
have too many inmates out here, Judge.
Oh, no. No, I'm just wondering. He said he was on the 175th docket. If he's,
He has a case in the 175th.
okay, so why is he here?
No, MTR.
Well, who has the Lord J in? Because, all right, so we need to see if he still needs to be here.
Not sure, Your Honor. He's on the MTR docket.
MTR.
Okay, so we'll see if he should still be here or if he should be totally in the 175th.
Okay.
Jason, I'm gonna reset Rick Contreras. He's on page 28, but defense counsel is telling me he's not here because he's also on the docket in 175th.
He's in
Yes,
custody.
you mentioned that earlier.
So maybe he shouldn't be with us. So we shall see.
I don't know if the MTR is, we have an MTR here.
I think yours is older.
If ours is older, they should be transferring it.
But I don't, it's not I think I've been dealing with Mr. Peter down there. So if possible, maybe I know the policy, but we could just move it down there.
All right, so we're gonna recall this for June 27th.
Okay.
And we'll see where we are.
Thank you.
All right, thank you.
Your Honor.
Yes.
Thank you.
Please swear affirm the testimony you give will be the truth and nothing but the truth, so help you God. All right, you can lower your hand. Make sure you keep your voice up so that the court reporter can hear and I can hear.
Fine.
All right, state your name for the record.
Christina Villarreal.
All right, defense.
Yes, Christina. Can you please tell me your relationship to Rebecca?
She's my girlfriend.
And how long have you known her?
About 4 or 5 years.
Okay. And if this judge sees fit to put her on deferred adjudication probation, will you help her get to any appointment she has to get to?
Yes, I will. I have a car, so there's no need to reason why she can't be able to get anywhere or do anything that she requests.
And are you aware she's had a heroin problem?
Yes, I'm aware.
Do you have a drug problem?
No, I don't have a drug problem, never been in jail.
Okay. And would you tolerate her using drugs in your house or in your premises?
No.
Okay. And do you think she may be a good candidate for probation?
Yeah, she's a good person. She has a good heart. She can work. She should be good for it.
Okay. Is there anything else you want this judge to know that might help her make a decision on this matter?
Just if you grant her the probation, that she'll comply with everything that you do. Like I said, there's no reason why she shouldn't be able to. I have a car, I have everything she needs. I got it.
Any questions?
Yeah, where did you meet?
She's an old friend of mine.
Where did you?
Just around the way. We know similar people.
Like 4 years ago, 5 years ago?
About 5.
Did y'all meet in a store? Did y'all meet?
Yeah, prior I used to work at 7-Eleven, so came into my store.
Have you ever been to prison?
No, I haven't. I've never been to jail either.
She's been to prison.
Yes,
right?
I do.
She was convicted of robbery.
It's okay. That has nothing to do. Her past has nothing to do with me. It's the present.
My question was that you're aware of that. Is that
I'm
correct?
aware.
And when did you meet her? What year?
I'm not quite sure. It's about 4 or 5 years ago. If you want to come back then,
2020 or 2019?
if you want to believe so, yeah. I mean, I don't remember. It's been a while.
Okay, well, you said 4 to 5 years.
4 to 5.
It's 2004, 24.
Yeah.
minus 4 years is 2020.
I mean, if you want to say so. But like I said, I know 4 or 5 years. I mean, going back doesn't really mean anything.
Only one person can talk at a time to the court reporter. Okay?
Sorry.
All right, so what I'm going to ask you to do is I want you to listen to the questions that are being asked of you and answer the questions. Do you understand?
Yes, ma'am.
All right. State, you may continue.
Thank you, Judge. I'm just asking these questions so we get a full rounded picture of your relationship with her, because you're saying that you're gonna be there for her and
Yes.
help her. Is that correct?
Yes, it's correct.
And when she picked up these cases for possession of drugs, you and David.
Yes, I was sure.
And then in February of this year, 2024, you're also dating of robbery. Is that
Yes.
correct? No further question, John.
I'm finished with the show.
All right, I have a few questions if there are no objections. All right, so I'm trying to figure out, how long have you been in a relationship with her?
Like about, I mean, just recently, like about 2 or 3 months.
All right, do you have children?
No, I don't.
Does she have children?
No, she doesn't.
Okay. All right, thank you so much for coming down.
Thank you. Kristen, help us. My next witness is my client.
Oh, if you come forward. Can you raise your right hand for me? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna have to keep your voice up so that so that I can hear and so that the court reporter can hear. You can lower your hand, state your name for the record.
Rebecca Jean Harris.
All right, defense.
Rebecca, please understand only one person can talk with the court reporter. And so it's a little bit awkward as far as the normal conversation, but please remember that. Can you please tell the judge about what your drug problem has been?
Been addicted to heroin. I've been struggling with this addiction for the last 3.5 years.
And since you have been locked up, how long have you been locked up?
Since February 2nd.
And have you had access to heroin in the jail?
No, sir.
And are you clean now?
Yes, sir.
Do you have any more desire to use heroin?
No, sir.
Now, if this judge did put you on deferred probation, would you abide by all the terms, including any type of drug treatment that may be recommended?
Yes, sir.
Do you think you need drug treatment?
Yes, sir.
Now, if you get out, do you have a place to stay?
Yes, sir.
Where?
My sisters or at Christina's.
Can you speak up so she can hear you?
My sister Ruby's or Christina's.
And would you be able to get a job again?
Yes, sir. With my former, I used to work at Blue Star Brewery, and he's willing to give me another shot.
Blue Star Brewery?
Yes, sir.
And what do they do there?
It's a brewery. I was a dishwasher there.
Okay. You don't have access to any drinking there, do you?
No, I don't drink.
And are you asking this judge to give you deferred probation?
Yes, sir, I am.
And you're gonna abide by the terms and conditions of their?
Yes, sir.
And this is a first degree felony, even with the waiver of the repeater. So do you understand the range of punishment if you were to get revoked?
Yes, sir.
And what is the lower range?
5.
And what's the upper range?
18.
No.
Oh.
If you get revoked, the upper range on a first degree felony.
99, right?
That's correct. You don't want to come back here, do you?
No, sir.
Okay, pass the witness.
State.
Yes, on the day, February 2nd, 2024, what were you and your friend doing?
We went to JCPenney's and I was trying to make ends for my drug habit.
Okay, so you were stealing from there? When you left, the knife was pulled on the employees there?
Yes, sir.
Y'all were stopped under a bridge by
Yes,
the
sir.
officers?
Yes, sir.
And you were convicted of robbery, and spent 8 years in TDC, is that correct?
For my past, yes.
Thank you. No further questions, John.
Just wanted to follow up on that. At that store, did you personally take anything out?
No, sir.
What did you do with the merchandise when you
I emptied my backpack and threw the items inside the store. I never left the store with it.
Okay, but you were with someone who did leave the store with it,
Yes,
correct?
sir.
All right, which is probably why you're here today.
Yes, sir.
Now, as far as in the store, was any knife pulled in the store?
No, sir.
What was the purpose of the knife being pulled outside of the store?
He was pushing on her and he's a male. I mean, she's a female. He didn't identify himself. He didn't say he was loss prevention. I mean, after he said he was going to tackle her, I felt the need to step in and I pulled out a pocket knife.
Did you cut anybody?
No, sir.
Okay. That's this.
He didn't identify himself,
No, he didn't.
so he just ran up to you
Yes.
and grabbed you
He put his hands on her.
on her,
Yes.
and so you pulled out a knife.
Not till after he threatened to tackle her and we were already out the store. And I already had opened my backpack and gave him the items. Like, I never left the store with any items.
Maybe you did, but your friend did, that you pulled the knife out for the protector, right?
Yes, sir.
So you knew who the person was coming to stop you.
That didn't happen until after he didn't identify himself. He went to go push on her.
Did you or did you not know who the person came to stop y'all from stealing?
Once I put the knife out, I guess, yes.
Okay, no further questions.
I don't have any more questions, John, but if you do, have no objections. You were asking for deferred.
Oh, just one moment.
Sorry.
All right, I'm reading the stipulations and it states Rebecca observed Damien following her. So she told him she was not stealing anything. Rebecca removed items from her backpack and walked out the exit door. So the person who was following you all was Damien. And in the stipulations, it says you observed him following you and you told him, you actually spoke to the person. So the person who came running after you and the friend that you were with is the same person who you said, I'm not stealing anything. So are you still saying that you didn't know that this person worked security or was an employee of the store?
I don't recall telling him any of that.
Okay. And what is your relationship to Rebecca? I'm sorry. Yeah. What is your relationship to, just one moment. Who is this? We always have people who want to be attorneys. All right. What is your relationship to Corianne Valent?
None. She's an ex.
All right. So that's your ex-girlfriend that you were with?
Yeah.
All right. And so while you were with her, I'm not trying to start any trouble, but while you were with her, were you still with the person who came to testify on your behalf? Because her timeline of dating you is during this incident.
Corinne was an ex. We weren't in a current relationship.
Okay. All right. I always just have questions. Okay. All right. Any other witnesses from either side?
Nothing from the state.
No, yeah.
All right. The court will hear argument. State.
State's asking for 18 years.
I'm sorry. You said you're asking for 18 years. There's only one case, correct?
There should be two cases going on.
All right. Let me see.
I thought it was one case and I thought.
sorry.
Yes,
I
I
thought
only have one.
The enhancement was waived. No, not waived, but
Oh, I'm sorry. He gave me two cases.
I'm sorry.
Okay. So there's only one.
Yes, sorry, I apologize.
Another case, my fault. It's another case.
No problem.
Your Honor, I gave you those are for the other one.
I'm sorry.
I didn't read the name on the file.
I'm sorry.
Okay. All right. Defense state is requesting 18.
Your Honor, we are requesting some type of deferred, obviously it can only be up to 10 years for deferred that actually takes place. My client is willing to do whatever she has to do to comply with the terms and conditions of probation. She does have a support system that we're here, and she is willing to go to any kind of drug treatment that's recommended or required. And she knows that if she blows this, she's looking at possible 99 years of, you know, not that that's always given, but she could get a long time on this thing. She did not take anything out of the store. However, she was with someone who did. And she apparently pulled a knife, and what she says is a defense of this other person outside the store. My client at that time was homeless, living under a bridge, which is, I think, where they arrested him. So we are asking for deferred.
All right. So, Ms. Alvarez, I want you to know that I understand that any time that somebody does in custody, it's a lot of time. I remember when I was a defense attorney, you would have some prosecutors saying, oh, a person can do that time standing on their head. And I always tell that prosecutor, have you ever done time? Because if you have not, you can't tell me that somebody can do time standing on their head. But both you all have talked about your prior, which is a robbery. So a robbery, the difference between that and aggravated robbery is there's not a weapon. And so you've gone from committing a robbery that you went to prison for to now it's aggravated robbery. And I don't know why people who are in the wrong feel the need to pull weapons. I mean, both you, from what I read in the stipulations, both you and the person, your ex that you were with, you all were stealing from JCPenney at North Star. And this person is just trying to do their job. I don't know if he receives a bonus from stopping theft or not, but he's just trying to do his job. And ladies, you can't start a fight hitting on somebody. Should a guy hit a lady back? Absolutely not. But you can't fight a guy and then say, oh, don't hit me, I'm a lady. You can't steal from JCPenney at North Star and then say, oh, don't chase me. Don't grab me and bring me back to the store because I'm a lady. You understand? All right, this is what the court is going to do. The court is going to find you guilty. There's an affirmative finding of deadly weapon. Court is going to sentence you to 18 years in the prison. Give you credit for any time served. There's to be no contact with Corien, Corien, Valent, Valent. There's to be no contact with North Star Mall. And there can be the therapeutic community. If you have a drug issue, the therapeutic community does not increase the time that you're in custody. But I have no jurisdiction to force them to allow you in the program. So you'll have to request it. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? Did you sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. We can go off the record. Here's the thing. If you pick up another felony in Texas, depending on the level of felony it is, that's going to put you in a status as being a habitual offender, and your minimum will be 25 years, and you will not be eligible for probation. Do you understand? All right, good luck to you.
May I say one thing, Your Honor?
Yes.
And I'm sure the court's already aware of this. I just need to state this to make sure it's on the record. There were 2 counts. The first count was ag robbery. The second count was robbery.
Yes.
That doesn't change, what she did or didn't do, but the count 1 had been waived.
Yes, no, the count that was waived was count 2.
Yes, it was.
Yeah, count 2 was the one that was waived.
The ag robbery was waived.
No, let me see the file.
I promise you, it was the ag robbery. But they did say that they kept the repeater because they wanted it to be a first degree.
No. Count 2 was waived and the enhancement was waived, and they proceeded on count 1, and count 1 is the aggravated robbery. All right, thank you.
She stole to feed her kids, but the judge warned her this was her final chance. A woman charged with identity fraud stood in court admitting she used meth, lost her job, and made terrible decisions while trying to support her children. The courtroom became emotional when she confessed she took advantage of an opportunity because she desperately needed money at the time. The judge questioned her directly about her addiction, her children, and why she kept taking things that didn't belong to her. She admitted she was high on meth when the crimes happened and had fallen apart financially after losing work cleaning houses. Despite the serious felony charges, the judge surprisingly decided not to send her to prison immediately. Instead, the court handed down strict deferred adjudication probation with intense drug treatment, parenting classes, community service, random drug tests, and heavy restrictions on where she could work. The judge even banned her from jobs involving homes, money, checks, or children because of the nature of the offense. Then came the warning that changed the entire tone of the hearing. If she violates probation, she could face up to 10 years in prison. Do you think the judge gave her too many chances or exactly the help she needed?